Okay, we're on the record. This is the People versus Carlos Lorenzo Durham. Case number 2259974. Count one. Only count one. Police officer.
This woman walks into court facing yet another OWI charge, while still on probation from a previous one. But instead of showing accountability, she flips the courtroom into a chaotic performance. What should be a legal proceeding quickly turns into a personal drama where she plays the misunderstood victim. Just a quick reminder for those unfamiliar, repeat OWI offenders are usually ordered to install ignition, interlock devices on their vehicles. These systems are designed to prevent a car from starting if the driver has alcohol in their system, acting like a built-in safeguard against future mistakes. So here's the big question. Did the judge do enough to control this courtroom spiral? Or was there a more effective way to bring order to the chaos? Let's break down what happened and see for ourselves.
And reporting. This is a habitual offender report, offense notice, and also case number 2258771, People versus Carlos Durham. Mr. Durham is charged on this case with count one, weapons, firearms, possession by a felon. Count two, weapons, felony firearm. Count three, weapons, ammunition, possession by a felon. Count four, weapons, felony firearm. Count five, carrying concealed. Count six, police officer assaulting, resisting, and or obstructing. And this is a habitual offender fourth offense notice set for a bond redetermination hearing. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Delisha Taylor Coleman, P56278 on behalf of Mr. Durham on both matters for bond redetermination.
And Mr. Durham, can you state your full name for the record, please?
Carlos Durham.
The situation is already serious. And somehow she makes it worse by turning on her own attorney. The same one who handles these kinds of cases professionally every single day. She accuses him of failing to explain the legal terms properly, and claims he pressured her into signing a waiver, all while conveniently forgetting the fact that she was caught driving under the influence. Her entire defense hinges on pretending not to understand basic legal procedures, as if that wipes the slate clean. At some point, you've got to wonder, does she need a new lawyer, or just a reality check from the bench?
Thank you. And whenever you're ready, Attorney Taylor Coleman.
Yes, Your Honor. As the court has before it, I believe Mr. Durham has a capias with this court, or maybe it was with Judge Elise Bryant. At this point, we'd ask for any capiases to be recalled. That he is a resident of Detroit. He has significant family contacts. I'm looking up his investigation report. I'm looking up the sheet from misdemeanor felony defenders on his behalf. Long story short, we're asking for a personal bond with tether, and that he would reappear at all future court dates. The rest of the capias of December 14th, Mr. Durham.
I'm sorry, what did you ask him? I didn't hear the first part of your question.
Address the alleged, not alleged, the capias of December 14th of 2022.
Yes, go right ahead.
Mr. Durham, were you aware of that court date?
There's something especially frustrating about hearing someone complain about the consequences of a crime they were clearly caught committing. She acts like probation is some kind of personal injustice, when in reality, it's the minimum penalty for a DUI in many places, and now she's bragging about getting a reckless driving charge dismissed as if that somehow lessens the weight of the OWI that remains. Let's be clear, the OWI charge is the serious one, the one that stays on your record and brings the hammer down in court. You don't walk into a courtroom with a DUI and expect hugs and hyphas, you expect consequences.
Yes, and kind of no. They bombarded me with a bunch of court dates, and I kind of might have forgot it because there's so many I got to go to. Okay, they sent me about 40 different cars with court dates on.
You essentially made up your court date.
I think so. I got court dates all the way to February, and I think I just missed it out.
Okay. Would you reappear at all future court dates, Mr. Durham?
Yes, I reappeared. I appeared before. I was on Zoom. I was on a tether. I came to court.
Okay. Your Honor, we believe that this was just a mistake, a one-time mistake. Mr. As the court can see in the register of action, Mr. Durham had appeared at previous court dates, but as he stated, because of the number of court dates, this one fell through the cracks, but he would reappear at all future court dates. These are non-assaultive crimes. We're asking for a personal bond, reinstate the bond with tether. Would the court consider any reduction at all? I don't know if Mr. Durham can post any amount of money. Was there a change in your bond before Judge Bryant, Mr. Durham?
So the what? I didn't hear you.
Was there a change in your bond before Judge Bryant?
Yeah, it was a $10 bond. That's all it is. They said it's a $10 bond. I'm here to get this bond reduced so I can get out of jail.
And you have employment?
I work for myself.
Okay, so I'm still going to keep it the same, Attorney Taylor Coleman. Because of the cases on both cases, I am going to wait until we get to the probable cause conference on the 25th with the DSU report to determine whether or not I'm inclined to reduce the charge. I need him to show the court for something, because we're back at the probable cause conference. I want you to listen up very carefully. Your next court date is January 25th. That is a Wednesday at 8:30 a.m. Can you hear me?
Yes, ma'am.
Okay, so you'll be zooming in from the county jail, and you'll have an attorney present to discuss with you any matter before we go on the record, okay? So show up for that. Well, you have to show for that. Then your attorney then can possibly discuss something once we have a DSU report, okay? Attorney Taylor Coleman, anything from defense?
That's it. Thank you, Your Honor.
All right.
By now, you'd think she'd want to play it smart, but instead she goes on the offensive again. The judge had already told her he wouldn't be extending her probation, and yet she still went out and picked up another charge. Now she's acting surprised, almost angry, as if she thought that meant she could go back to drinking and driving without a problem. But that's not how probation works, and misunderstanding the rules doesn't earn you a free pass. Courts don't operate on vibes, they run on facts, terms, and legal boundaries. If you don't get that, it's not the judge's fault.
Okay, gentleman from the county jail who just sat down about 5 minutes ago, can you state your name for the record, please?
My name?
Yes, your name.
My name is Carlos Lorenzo, and I'm here to represent the person you got on that paper, which is an all capital name, all capital letters. That's a corporation, and I'm not claiming to be him, but I'm here to represent him. All capital name is all corporation. I'm not a corporation. I'm not dead. I'm not a fictitious entity. So I'm not claiming to be whoever name you have on that paper, which is probably in all capital letters. That's not my name. It's two names in this court that sound exactly alike, and only one of them is mine. What name is on that paper y'all have over there? Is it in all capital letters? That's not my name, but it's my property. It's my trade name, and I own it. And I need to know if anybody has permission to use it from me. So do we have that understood? I am not a U.S. citizen, and I'm not a citizen of the United States. I am not that person on that paper, because that person is a fictitious entity. I am actually flesh and blood. I am a man standing on the land, and that's what I got you. Do you understand that? I'm not him. I'm claiming not to be him.
I just wanted to know who you were. Thank you. I had to check there. Attorney Simon, thank you. You want to speak to your client in private before we go on the record? Because he's still talking.
Sorry, Judge. Can you repeat that, please?
Do you want to speak to your client in private for a moment? Because he hasn't stopped talking for the last 10 minutes. He's still talking. He doesn't know he's on mute, but he's been talking.
I just saw him Monday at the jail, but okay.
Okay. Because I don't think we can have his hearing unless he understands we all can't talk at the same time.
All right, I'll do a breakout.
Let's be clear. No one's trying to keep her stuck on probation longer than necessary. In fact, the court probably hopes never to see her again. And while she's losing her cool, the judge stays surprisingly calm, which only highlights the gap between her emotional outbursts and the court's focus on order. His measured tone might be unsettling, but it's exactly what the situation calls for. Honestly, she should be grateful this wasn't in front of a zero-tolerance judge like Oakley, who wouldn't have had the patience for this level of backtalk. Right now, this courtroom feels like a powder keg and she's holding the match.
This is People versus Carlos Lorenzo Durham, case 2259974. Mr. Durham is charged with 1 count of police officer assaulting, resisting, and or obstructing. This is a habitual offender fourth offense notice. Also case 2258771, the People versus Carlos Lorenzo Durham. Mr. Durham's charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, stony firearm. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, stony firearm. Count 5, carrying concealed. Count 6, police officer assaulting, resisting, and or obstructing. This is a habitual offender fourth offense notice. Today's the day set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P8628.
Good morning, Your Honor. Jonathan Simon, P35596 for Mr. to both matters.
And Mr. Durham, can you state your name, please?
Objection. I'm not a mister. I just told you that it's two names that sound exactly alike and only one of them is mine. My name has never been spelled in all capital letters, so that is not my name. Whatever name you have on that paper is a corporation and it does not exist. That's not who I am. I'm not.
What is your name?
I'm here to represent him.
What is your name?
My name is Carlos. That's what I go by. My name is not Mr. and I never spelled it in all capital letters. I keep explaining that to y'all, but y'all insist I'm that dead entity on that piece of paper, and I'm not.
What is your last name?
What is your name, ma'am? Can I have your name and your oath of office, please? Did you take an oath upon the Constitution, ma'am? Or did you take an oath to violate my constitutional rights in conspiracy with the prosecutor and the Detroit police?
Attorney Simon, what I'm getting here is that Mr. Durham is not present.
Objection, I'm not a Mr.
I can enter a capias because that's not Mr. Durham. Or
Judge, maybe we could have a competency referral.
he knows what he.
If there's one lesson here, it's that blaming others won't save you from the facts. Her next case is approaching fast, and it's clear she still refuses to accept responsibility. This is exactly why DUI charges come with long-term consequences of probation, court-mandated programs, steep fines, and strict conditions just to begin rebuilding your record. What's wild is, she's still pointing fingers, even turning on the judge like he somehow caused all of this. So what do you think was the court fare, or should it have taken a tougher stance? Let me know in the comments. And don't forget to like and subscribe for more courtroom cases with real stakes. Appreciate you watching, and if you still think this was an AI voice, I'll see you in cross-examination.